So the court will call cause number 323-114-711-20 to style the matter of Alan Basilvilvazo. We are here set for adjudication on the matter. The court will take notice that on October 29, 2020, there was a petition regarding the child engaging in delinquent conduct, alleging one paragraph of delinquent conduct. The child was served with a return on the summons with a file date of November 2nd, 2020. Subsequently, a first amended petition regarding the child engaging in delinquent conduct was filed on November 10th of 2020, alleging 4 paragraphs of delinquent conduct. The child was served with that first amended petition with a return file mark on a return date of November 11th, 2020. The court will also take notice that on a document file marked November 20th of 2020, the grand jury of Tarrant County convened and gave determinate sentence approval on this matter, signed by the foreman of the grand jury and the presiding judge over that grand jury. The child was served with a copy of the summons on November 25th of 2020 with a copy of the grand jury approval and petition, and the mother of the child, Dylan Martinez, was also served with the grand jury approval on December 2nd, 2020. We are now here for adjudication. Filed with the court is a stipulation of evidence, judicial confession, and disposition agreement. Filed with the court under seal is a victim's court report and a social history. The court has yet to view the social history in compliance with Texas Family Code. Mr. Basilvilvazo and Ms. Martinez. All right, if you can both raise your right hands for me. Ms. Martinez, I think you're on mute, so I need to, can you unmute yourself? Thank you. All right, if you can both raise your right hands. Oh, wait, you unmuted and then muted yourself again.
You're talking to me, Judge?
No, I'm talking to Ms. Martinez.
I'm sorry.
All right, so do each of you solemnly swear the testimony you're about to give at this cause currently trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Basilvilvazo? Right, Alan, can you hear me?
Sure.
Okay, so can you raise your right hand? You solemnly swear the testimony you're about to give at this cause currently a trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God? Sir, you solemnly swear the testimony you're about to give at this cause currently a trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God? Is the microphone not working? I mean, it's working.
I swear to tell.
I'm sorry?
You said you want me to repeat what you just said?
No, I'm asking you if you swear to tell the truth.
Yes, sir.
You said what?
Say yes, sir.
Okay, you can lower your hand. Alan, look, if you don't want this deal, just let us know and we can have a trial.
No, I want this deal, sir.
All right, then what's with the attitude?
I don't got no attitude, sir.
All right, so you're telling me that I'm lying to you, that you don't have an attitude right now?
No, sir. I'm just saying I don't got no attitude.
Mr. Vavazo, I'm going to try and go through this. But do you do this with respect for the court, or we're just not going to do this? All right?
Yes, sir.
You've had all kinds of problems in detention hearings, including flipping off the court with both hands, cussing at the court. As I told you in detention hearings, you have to understand that with your case, this all comes through the court. If you're going to show a high level of disrespect, this will only come back and hurt you. So this is your chance to either get it straight and go through this and show some respect for the court, or we just have a trial and let a jury decide what's going on with you and what's going to happen in your future. You understand?
I understand.
Who do you keep on looking at?
People keep walking in the door.
So who's walking in the room?
Staff.
Who?
I'm saying like people keep walking in the front door. I'm listening to you.
So do we have security control in there?
Yes, sir, we're here.
Can you turn him around so he's not looking at the window?
Sure, Your Honor, give me a second.
Thank you, sir.
Yes, sir.
All right, so Alan, can you tell me what your full legal name is?
Ellen Basa Vilvaso.
Okay. You don't have a middle name?
No, sir.
What is your date of birth?
8/14/2004.
Are you an American citizen?
Sir.
What?
Yes, sir.
Alan, you've got to stop dropping syllables. Say yes or no. It's really that simple.
All right.
So, Alan, I want to let you know that you're looking at determinate sentence offense for aggravated assault with a deadly weapon. That means you're looking at up to 20 years of commitment in the Texas Juvenile Justice Department and the possible transfer to the Institutional Division of the Texas Department of Criminal Justice. In that, if you are committed, this could be used against you in adult criminal proceedings if you're ever to be charged as an adult. You do have a right to remain silent. You do not have to say anything at all. However, my understanding is you wish to admit your responsibility in the aggravated assault of a deadly weapon, the possession of a controlled substance from 4 to 200 grams, the possession of marijuana more than 4 ounces but less than 5 pounds, and possession of a controlled substance under 1 gram. Do you give up your right to remain silent?
Yes.
I beg your pardon?
Yes.
And do you understand that if you're committed, this can be used against you in adult criminal proceedings?
Yes.
You also have a right to have a trial. You do not have to agree to anything. However, your attorney represents to me that you wish to say that you're guilty of these offenses and that you do not wish to have a trial, that this would be your trial today, and there would be a disposition or a punishment determined today without the benefit of a trial, where the DA would have to prove all their evidence against you. Do you give up your right to a trial?
Yes.
You also would have a right to have a jury make this decision. So if you do not like me, or if for that reason or any other reason or no reason at all, you have the right to have a jury of 12 people listen to the same evidence I would hear, and they would decide whether or not you committed these offenses. Do you give up your right to a jury?
Yes.
You also have a right to appeal. However, If I follow this agreement, which is 5 years commitment in the Texas Juvenile Justice Department, you are giving up your right to appeal. This will be final. You understand?
Yes,
Is that a yes?
yes,
You also have a right to confrontation. That means any witness that was harmed or involved in the case that will be used against you, you have the right to look them in the eye as they testify against you during the trial, whether before me or the jury. Do you give up your right to confront adverse witnesses?
yes.
You understand what I said?
Not really.
Okay. So if somebody testifies against you, you have the right to see them and look them in the eye as they're testifying. That way, if they're lying, they have to lie to your face. Do you need to have witnesses that are testifying against you? Do you have to look them in the eye while they're testifying?
I gotta give them my right for that.
Yes, you have the right to face your accusers. People are accusing you of breaking the law. And the law says you have the absolute right to look them in the face while they're testifying against you and saying that you committed a crime. And if they're lying, they have to lie directly to you in front of you. And that's your right. So you have to give up that right because we're going to go forward without the witnesses. If you want to face your accusers, we can have a trial and you can face your accusers.
I give up the right.
Okay? Now, do you understand? I'm not required to accept this agreement. I can reject this agreement. Your attorney can go back with the DA and renegotiate if I do not approve it. However, and I can also delay this, but I can delay accepting this agreement until after I read the social history. You understand? I do not have to, you do not force me to accept this 5-year commitment.
I understand.
Okay. Mom, I've sworn you in previously. Can you please tell me what your full legal name is? Mom? Ms. Martinez?
Dailene Martinez,
How do you spell your first name?
D as in David, IELIN.
And can you tell me what your relationship to Alan is?
He's my son.
Thank you. Mr. Green, is there any reason why your client will not understand the proceedings today?
No, Your Honor, I believe he's legally competent as defined in the law.
Okay, and so he is fit to proceed?
Yes, Your Honor.
Thank you. Alan, you are here today because the state of Texas has alleged that they have filed a petition alleging you have engaged in delinquent conduct, which, if committed by an adult, would constitute an offense against the laws of Texas. Namely, in paragraph 1, they're saying on or about October 8th in 2020 in Tarrant County, Texas, that you intentionally and knowingly caused bodily injury to Caleb James Parsons by shooting him and that you used or exhibited a deadly weapon during the commission of the assault, namely a firearm. They're also saying on the same date that, on or about October 9th of 2020, that you intentionally or knowingly possessed a controlled substance, namely cocaine, of 4 grams but less than 200 grams, including any adulterants or dilutants. They're also saying in paragraph 3, on or about October 9th of 2020, you intentionally or knowingly possessed a usable quantity of marijuana of more than 4 ounces but less than 5 pounds. And in paragraph 4, they're saying that on or about October 9th, 2020, in Tarrant County, Texas, you intentionally or knowingly possessed a controlled substance, namely methamphetamine, of less than 1 gram, including any adulterants or dilutants. Do you understand what they're saying that you did?
I understand.
Mr. Haynes, do you waive opening?
Yes, Your Honor.
Any exhibits for adjudication from the state?
No, Your Honor.
Any exhibits from the respondent? For
No,
adjudication?
Your Honor.
So, Mr. Bazavilvazo, your attorney went over a stipulation with you, okay? And so, you understand what a stipulation is?
It's the thing that got to do with the deal.
You know what the word stipulation means?
No,
Stipulation is a legal word to say an agreement. So if you stipulate to something, that means forever and ever, you can never go back and argue about what's in the stipulation. So there's a stipulation here. If you say you agree to it, that means 50 years from now, you cannot go back and say, I was forced to sign this, I was forced to agree to it. You can't ever argue it. It's set in stone. Do you understand?
I understand.
So the stipulation here that I have is that you're admitting to the 4 paragraphs that I said to you, the aggravated assault with a deadly weapon, a firearm, that possession of a controlled substance between 4 and 200 grams, marijuana 4 ounces to 5 pounds, and possession of methamphetamine under a gram. All right. So is it true or not true that you shot Caleb James Parsons with a firearm?
True.
Is it true or not true that you possessed cocaine more than 4 grams but less than 200 grams?
True.
I'm sorry?
True.
Is it true or not true that you possess more than 4 ounces of marijuana but less than 5 pounds of marijuana?
True.
Is it true or not true that you possess less than a gram of cocaine or methamphetamine?
True.
Now, are you saying true because it is true and for no other reason?
Sir. Sir.
Can you repeat that?
Say yes.
So are you saying true voluntarily?
No.
Okay. Is anybody forcing you to say true?
Oh, no. I'm saying it because it's true.
Okay. Nobody offered you any kind of bribe or a reward to say true?
No.
Okay, so you are saying true because it is true and for no other reason. Is that correct?
Yes.
Mr. Haynes, stay wave close.
Yes, Your Honor.
All right. Mr. Green, wave close.
Yes, I do, Your Honor.
So the court, having considered all the competent evidence from this hearing, will make a finding of delinquency. Specifically, the court will find the allegations in the petition in paragraphs 1, 2, 3, and 4 were established by the evidence. The court will also make an affirmative finding that a deadly weapon was used. That will conclude adjudication of this matter. So the court will call cause number 323-114711-20. This is styled the matter of Alan Baza Vilvazo. We are here with the court having previously adjudicated this child as delinquent. We are now proceeding with disposition. Stay wave opening.
Yes, Your Honor.
The court previously took notice of a filed under seal victim's court report and social history. Are there any exhibits from the state as to disposition?
No additional, or no exhibits, Your Honor.
All right. Is there an allocution in this matter?
There is not.
Mr. Green, does the defense have any exhibits for this matter?
No, Your Honor.
So, Mr. Baza Vilvazo, what I have here is I have a social history that was prepared by Ms. Aguirre, and that goes into your background. I'm not allowed to look at this until after you've been adjudicated delinquent. Your attorney has had a copy of this for at least 10 days. Give me a moment, I can read this and make sure that it's consistent for me to honor the 5-year deal that your attorney got for you. All right, so Mr. Haynes, to stay wave close.
Yes, Your Honor.
All right, Mr. Green, wave close.
Waive close, Your Honor.
The court, having reviewed the social history, will make a finding that there's a need of rehabilitation and the protection of the child and the public requires disposition to be made. The court will honor the stipulated agreement between the parties. Mr. Baza-Vilvazo, I will commit you to the Texas Juvenile Justice Department for a period of 5 years. A couple things I want to tell you. First of all, the court will find that it is in the child's best interest to be placed outside the child's home, and that reasonable efforts were made to prevent or eliminate the need for the child's removal from the home and to make it possible for the child to return to the child's home, and that the child in the child's home cannot be provided the quality of care and level of supervision that the child needs to meet the conditions of probation, and that the child has behavioral health or other special needs that cannot be met with the resources available in the community. Mr. Baza-Vilvazo, I need to let you know that your case could potentially be transferred to the Texas Department of Criminal Justice. So I'm committing you to TJJD for 5 years. What's going to happen is you will go there, they will do assessments, there will be classes, there will be counseling. If you don't actively engage and participate in those, then what will happen is we will have a hearing where all that comes out. Your minimum period of confinement on this case is 2 years. You are 16 years old. And so it is possible for you to be released straight from TJJD if you do everything right. However, if you cause problems there, they will refer this case back to me and we will have a hearing before your 19th birthday, at which point I will decide whether you have done enough in TJJD for me to parole you, or if I'm going to transfer you to the Adult Institutional Division of the Texas Department of Criminal Justice to complete the remainder of your sentence. This is really up to you to decide if you're going to get your act together, be respectful, follow the rules, and do what you're supposed to do and take care of your business, or if you're going to act a fool and cause problems and continue getting fights and do what you want to do. If so, you will go to adult prison. Because I followed this plea bargain agreement, you do not have a right to appeal. Because this is a commitment on determined sentence, you do not have a right to seal your records. Mr. Baza-Vilvazo, do you have any questions for me?
No.
Mr. Green, Mr. Haynes, have I missed anything?
No, Your Honor.
Your Honor, I had agreed on behalf of Mr. Baza-Vazio to enter his apology for his contemptuous behavior in earlier hearings to this court.
All right. Ellen, look, I'm not personally offended. Like, I think you have a First Amendment right to hate me and not like me, and that's fine. But what you have to understand is I have a duty as a judge to maintain respect for the court system, okay? If you saw me on the street and you cussed me out, man, I'd shrug it off. I'm a big boy, I can handle that. That doesn't bother me at all. And I just put up with it because that's your right. But in a courtroom, you have to understand, you have to show respect for the court. There's a system and a process, and all judges have to protect that system and process. You understand the difference? I'm not saying you can't have an opinion. What I'm saying is when you're in the courtroom, that's what makes it different. Does that make sense to you?
I understand.
So if you see me on the street somewhere after you get out, if you want to cuss me out, that's fine. I mean, that's your call. You're not going to hurt my feelings. I'll be fine. But inside the courtroom, I have a job and a duty to protect the respect for the court. Do you understand you know the difference, right?
Yes.
Okay, good. All right, well, apology accepted. The court will dismiss the contempt action from now. Well, there's already been a finding of contempt. We're just going to go on the sanctions for the contempt, and the court will assess no sanctions for the contempt. All right. Any other matters we can take up?
Not from the
One
state,
thing-
Your Honor.
Okay. All right. Thank you. That'll be the order of the court.
I waive my motion.
I beg your pardon?
Just for the record, the respondent waives his motion.
Oh, his motion. Okay. All right. Thank you.
Thank you.
Thank you so much.
So, Sheriff, I see you're there. Which child are you here for?
We have Jalen Rice down here with us. We're
Okay.
not sure what time he's going, so.
I think Jalen Rice is set at 9:30. So we're waiting. Mr. Glassman had popped in. He stepped out. The attorney popped in the courtroom, but then left. I think he's inside the courthouse or the hallway somewhere, but I'm not sure where.
You want us to get him out? Is he next or?
No, let's wait. I'm not sure what they're doing with the case yet. They haven't reported to me.
Okay, all right, we'll hold off till you tell us.
Thank you, sir. Mr. Pearson. All right, for Joshua Ballard. Okay, and I think we're waiting on Janet.
Your Honor, I'll get and bring her into the room, sir.
I'm sorry?
I said, the mother's here. I'll take her into the courtroom if you're ready for her, sir.
Thank you.
Your Honor. I was on at 8:30. I don't know if y'all were waiting on me. If you did, I apologize. I clicked on and it said wait for the meeting to start. So
No, I saw you in the waiting room for a little bit. The last kid was a difficult child.
So
I was close. You know me. I was like, you know me. I was like talking back there.
Yeah. How are you? Good, how are you? Good.
Which one is it? Oh, I see it. Okay.
I'll meet with you afterwards.
I didn't know what else I could do with them. I mean, you just wouldn't talk. So what? I mean, I was right at the edge. We're just waiting on Mr. Ballard. Mr. Jennings, are they trying to get Mr. Ballard?
I'm doing it right now, sir.
All right, thank you.
Your Honor,
Yes.
I just got a message that Amador was passed. Is that correct?
Yes. Turns out Amador is demanding a jury trial.
All right.
I just found out this, so they were resetting that case.
Hey, thank you, Your Honor.
Thank you. Let's see. Mr. Youngblood, is there anything we can do with your case while we're waiting on the child?
I don't know if Kevin is on here or not. It's a status deal. Your Honor, I am signed up to get a COVID vaccination, but I haven't gotten it yet or been told exactly when it'll be. I've been signed up for 2 weeks. I would hope to get the vaccination and then have enough time, usually about a week past that, to make sure I didn't have COVID before I got the vaccination. And then I would ask the court, and I talked to Mr. Blumberg last night about this, to give me a Friday afternoon in one of the jury rooms with my client so that he may go over all the electronic media type evidence and see for himself things like pictures of the deceased and whatnot that the state will be offering in a trial. The offer on the case is 25 years, determinate sentence. And until he, in my opinion of his situation and his mental situation, the way he thinks, is until he sees this stuff for himself, he just won't get serious about telling me exactly what he wants to do with his case. So I'm hoping to reset this case for far enough out to give the court an opportunity to do that. You and I had talked about it in late March when I first got the case, but then unfortunately the system sort of shut down. Back in late March, you were open to the idea. I don't know if you remember this anymore, and you've always been open to this sort of thing. So I don't think it's an unreasonable request, and I think Mr. Blumberg is going to be okay with it too from our discussions yesterday, but I don't see him on the Zoom meeting right now.
I'm here.
Oh, there he is. Okay. So if I'm wrong, he'll correct me.
Sorry, Edwin, I missed the first half of your sentence there.
He's looking for, so Mr. Youngblood, when is your vaccination supposed to be?
I don't know. I signed up 2 weeks ago. A bunch of people have already gotten them. I don't know when the health department will be doing this. They acted like it would be a matter of a few weeks, but I haven't gotten a notice from them. They're supposed to send me an email and a text telling me what day and time to show up at wherever it is they're going to do this.
Okay, so here's a tip. When they tell you the date and time, just show up first thing on that. Don't worry about the time.
Oh.
When you're on the schedule, they're going to give you the vaccination that day. If you show up early, a lot of people miss and you'll get your vaccination quick. If you show up on time, there'll be delays. They'll take you.
Oh, well, thank you. That's great. And my wife is, as you know, a county division chief, and I'm assuming she'll be on a different place and a different time, but she is also signed up.
All right. So Mr. Youngblood, here's my problem. You're looking for the vaccination and test before you sit with your client and review the material.
Correct.
The problem is we don't know when that will be, when you'll actually get the vaccination scheduled. Once it's scheduled, you'll have to take a COVID test, which will take 2 weeks. Or no, I'm sorry, a couple days to get the results back.
All right, that's news to me. I didn't know that.
Yeah, so it'll take a couple days to get the results back. The problem is the vaccination is only good for about a month before you require the booster, and evidently they're not giving the boosters anymore. So
well, that's great.
the effectiveness of the vaccination goes down to 50% without the booster. Okay, so I can't, I mean, I appreciate your situation and I want to accommodate the best that I can. However, we're now dealing with a rolling window of the vaccination. So you'll evidently be 90-some% protected from contracting COVID for a month, and then it drops down to 50%, and then it drops down further. But they don't have enough vaccinations for everyone to get the booster. So that being said,
can I interrupt? Questions? Because this is important stuff. Let's say they don't get the booster done within the month. Does that make the whole thing ineffective, or?
No, it reduces the efficiency to 50%, from 90-something% to 50%, and then it decreases. There hasn't been enough study done to figure out how long you need the repeated boosters.
Okay, so we don't know whether when the booster happens it'll be effective, or we'll have to start the whole process over.
Well, so we know once you take the vaccination, the first shot, you're looking at close to 90% efficacy. And then if you receive the booster, you maintain that efficacy. However, if you don't get the booster, the efficacy drops to about 50%. Now, there hasn't been enough studies on when you need the third booster or the continued boosters, right? So we just don't know.
Okay.
So this is, I mean, it's a novel virus, so we're still figuring out as we go. So I'm just,
well, plan B might be for me to still get the Friday afternoon, bring my computer in, be masked up and whatnot. I'm sure he will be too.
So do you, Mr. Youngblood, do you have the DME in your files?
It's in a portable hard drive, so I can connect it to my computer and bring it in and just put it on play and walk out of the room until he's finished playing, I suppose.
Mr. Youngblood, would it assist you if we set him up with the computer and you could use Zoom where you could just share your screen?
I've never tried to do it. I don't know whether that works or not. If anybody else listening knows, that would be great. I don't know the answer.
It's just a share screen function is all it is. And you would be able to, I mean, you pick the window. You can play around with Zoom. And there's a limit, I think, I don't know, maybe an hour or so per session. So you would have to recreate, but we could facilitate.
This is long.
Yes. So you may have to recreate multiple sessions, but we can facilitate having the child available through Zoom to you so you can share the DME with him if that's all you need to do.
I believe that will work. Mr. Bomberg did some efforts to try to make the the DME more accessible. For a while, it was each picture, for instance, was its own file, and I think he put them in a zip file. Am I remembering this right, Kevin?
Yeah.
Okay. So it should work.
All right. So why don't we do that? That way we don't have to worry about the vaccination or anything else or the testing. We can do this immediately. So whenever you're available, and if necessary, what you can do is if you want to come to the courthouse and want to empty our Zoom terminals, we can set up here. If you're using the court Zoom session, there is no time limit.
Oh, okay. Well, once again, I think Friday afternoons generally work the best for your staff. Where would he be?
You would still be in detention.
Okay, where would I be?
In one of our rooms, either the small courtroom or one of the jury rooms.
Okay, well, it does sound like it will inconvenience some people if unless y'all are otherwise unemployed. So I can't do it this Friday. I don't know if Fridays are the best days.
Don't even think about Friday as being, it can be any day. We'll accommodate you.
All right, well, I'll sorry.
I'm sorry, Judge Kim, you waiting for Mr. Ballard?
Yes, we are.
Okay, I'm sorry. Mary told me we didn't need him today, but we got him back here.
All right, thank you.
Thanks.
Youngblood, you're saying?
Yes, sir. Well, then I'll get with Special K and get a date from her that works.
Okay. All right, so yeah, it can be any day. It does not, and actually you don't even have to be here. You could be in your own. Other thing about it, we can set up one of the court Zoom sessions, which has no time limit.
Oh, okay.
And allow you to share your screen from your office.
Even better. And that might take, Your Honor, even so, it might take more than one session to get this done.
No, it'll run. I've had them run for 3 days solid before.
No, I'm saying just because he may mentally wear out on it.
Okay, that's fine. So if you want to do it as early as this afternoon, that's fine, but just please let us know when you would like to make it happen.
And I'm fairly certain that Kevin has already opened everything there is to see. So this should work.
So when can I expect you to have the arrangements made for you to be prepared to?
I'll call Special K when we get off the Zoom here and I'll find out what works.
Okay, but I need something to put in the docket. Like, when am I expecting you to have this done by?
Let's see, today's the 7th. I've got one with you on Friday morning, and then after that, supposedly my day is free. So I'll try to start doing it then. I would say maybe it'd be safe to say by the end of the month anyway. It's the 29th as work days go.
You'll need 4 weeks to go over this stuff with them?
I don't know. I'm trying to make it so I don't keep asking you for resets. And Mr. Bumberg has made it clear that at the point where I feel like my client gets what he's charged with and either says yes or no to the 25 will, if he doesn't take it, go away. And we'll just have a certification hearing. And if he does take it, well, then we'll do a plea bargain and get it done. Obviously all in writing.
This is for certification?
It was set for that. Am I wrong, Kevin?
No, we've got a determined sentence approval judge as well as a petition for certification.
Okay.
So the Damoclean sword, so to speak, over my client's head is if he does not want to take the 25, the state's going to seek certification. Although the state's being reasonable, and if he makes some kind of close to 25 offer, we might settle it for that.
So, Mr. Youngblood, he's been in custody for 265 days.
Yes, he has.
All right. So I'm gonna have the certification hearing pretty quickly. I mean, At this point, it's just about certification. It's not his final trial on the merits. It's just this has gone on way too long. So really, this one shouldn't, I'm actually kind of upset with my staff because we shouldn't get to day 270 on this one in any circumstance. So.
Judge, may I interject on that point? Well, sort of related. As I understand it, the juvenile is still in the detention center. He is over 17, and I don't know if Ms. Castillo is on here, but I was made aware this morning that he did have some less than level 1 infractions in November and December. In fact, one being a level 3 confinement. I don't know if that's already been previously addressed or not.
I'm unaware.
Okay, I was just made aware of that this morning myself.
Yeah, if he was level 3, then he needs to be downtown. But
I don't see Ms. Castillo on here. I need to confirm that, Judge. I don't know.
Edwin, we're gonna, I mean, I know this doesn't help you, but we're gonna set this for final hearing on certification before the end of the month.
Okay.
It depends on Mary when she can fit it in. So you'll have to figure out time if you want to go over the stuff with them to avoid certification. The clock's ticking. So, all right. So Mary will tell you what date that we're going to set certification for on this matter.
Okay.
Hopefully you can find a way to make it work in between.
Now, because of the mask, I can't tell if the person that says juvenile is my client or not.
No, he's not. That is, I think, Mr. Ballard.
And earlier I saw a parent, but I don't know if it was my client's mother.
No, that is not.
Okay. All right. Well, then I'll get with Special K as soon as I sign off here and find out a date.
Okay. All righty.
I'll tell her that you want it done before the end of the month.
No, what I'm saying is I'll let her know that we're going to set certification in January of 2021. And whatever date she finds, if you're going to work out a deal for the state to waive certification, it would have to be before that date.
Understood.
All right. Thank you, sir.
All right. Thank you, Kevin.
Thank you.
All right. So we're here for Ballard. Okay, are we ready to proceed?
Ready, Your Honor.
State's ready, Your Honor.
Kelly? Well, we'll call cause number 323-114528-20. This is dialed in the matter of Joshua Ballard. We are here set for adjudication on this matter. The court will take notice that there was a petition regarding the child engaged in delinquent conduct filed on September 28, 2020, alleging one paragraph of delinquent conduct, that the child Joshua Ballard was served with a summons on September 30th, 2020. The court will also take notice that there was a grand jury approval filed on November 13th of 2020, and that the child was served with a summons on that grand jury approval on November 17th of 2020, and that the mother, Kenise Ballard, was served also with a grand jury approval on December 17th of 2020. All right, so Mr. Ballard and Mrs. Ballard, if you can both raise your right hands for me. Each of you solemnly swear the testimony you're about to give at this cause currently at trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Can you hear me?
I need a yes or a no.
Can you hear me? I say yes, sir. Can you hear me?
Yes, sir.
All right, thank you. You may lower your hands. All right, Joshua.
Yes, sir.
We are here for an adjudication hearing. All right. I have some questions to ask you and some things to go over with you. First of all, what is your full legal name?
Joshua Ballard.
All right. And what is your date of birth?
6/7/2006.
Can you say that a little bit slower?
6/7/2006.
Thank you. And are you an American citizen?
Yes, sir.
Now, I have to let you know a couple things. First of all, I need to let you know the nature and possible consequences of the court proceedings today. You're charged with a felony level offense, which means, and you have a grand jury approval, so that means potentially you could be committed to the Texas Juvenile Justice Department for a period of up to 40 years. Do you understand?
Yes, sir.
And that if you do get committed to the Texas Juvenile Justice Department, that you could be transferred to the adult prison before your 19th birthday if you don't do well while you're in TJJD. I'm not saying that's going to happen. You're getting probation. I'm saying this could happen. Do you understand?
Yes, sir.
Do you understand that if I give you probation, I'm expecting you to do probation right? If you mess up on your probation, then I can revoke your probation and send you to TJJD, and you could end up going to TDC. You understand?
Yes, sir.
Ms. Farmer, are y'all waiving determinate on this one?
That's correct, Your Honor, we are.
Joshua, you do have certain rights. You have the right to remain silent. You don't have to admit to anything, but your attorney is telling me that you want to admit to the aggravated robbery in exchange for getting on probation. Is that correct?
Yes, sir.
Okay. You also have a right to have a trial that you can require the district attorney to approve everything. But your attorney is telling me is that you don't want a trial. Is that correct?
Yes, sir.
Okay. You also have a right to confront your witnesses, to face your accusers. That means anybody that would testify against you and say that you broke the law, you have the right to look them in the eye as they're lying, if they're lying, in open court. Do you need to face your accusers? You understand what I'm saying?
Yes, sir.
You sure?
Yes, sir. I know what you're saying.
You know what I'm saying? So do you need to face your accusers?
No, sir.
Okay. So you also have a right to have a jury. So if you decide you don't like me and you want to have a jury decide whether or not you committed the aggravated robbery, you can have a jury make this decision. Do you need a jury to make this decision?
No, sir.
Okay. You also have a right to appeal, but if I follow this and give you your probation, you cannot appeal. This will be final. Do you understand?
Yes, sir.
All right. So, Mom, I had previously sworn you in. Can you tell me what your full legal name is?
Denise Nicole Ballard,
Can you spell your first name, please?
CANICE.
Okay. And what is your relationship to Joshua?
That's my son. I'm his mother.
Great. All right. So, Mr. Pearson, is there any reason why your client will not understand the proceedings today?
No, Your Honor, he is fit to proceed.
And he's fit to proceed. All right, Joshua, you're here today because the state of Texas has filed a petition alleging that you have engaged in delinquent conduct, which, if you were an adult, would be a violation of the laws, criminal laws of the state of Texas. Do you understand?
Yes.
And what they're saying is on or about August 22nd, 2020 in Tarrant County, Texas, that you intentionally and knowingly, while you were committing theft of property and with intent or to obtain or maintain control of said property, you threatened or placed Tyler Robinson in fear of imminent bodily injury or death, and that you used or exhibited a deadly weapon, specifically a firearm. You understand what they're saying that you did?
Yes, sir.
State waive opening?
Yes, Your Honor.
The court will take judicial notice of the stipulation filed with the court. There's also a victim's report and a social history filed under seal. And Ms. Farmer, I do have your 3914 manifest, which I have filed with the court. Are there any exhibits or witnesses from the state?
Not at this time, Your Honor.
Any exhibits from the respondent?
No, Your Honor.
All right. Joshua, do you know what a stipulation is? Have you heard that word before?
Yeah, I got the papers, but like I don't know really mean, but I know some.
That's fine. So stipulation is a fancy legal word for an agreement. Okay. So
Yes,
if I was to say that your mom is wearing a tie-dye shirt, is that something you'd agree with?
Yeah.
Yeah. Okay. So, 50 years from now, if we stipulated today, 50 years from now, we could not argue about what kind of shirt she was wearing today. You understand?
Yes, sir.
Okay. But if I was to say that today your attorney was wearing a pink tie, is that something you agree with?
I can't really see his top, but I guess so.
Really? What if I said he was wearing a bright red shirt? Would you agree with that?
No.
Okay. I couldn't. So we wouldn't agree. We couldn't stipulate because later on we may throw hands and argue about what color shirt was. You see what I mean?
Yes, sir.
Okay. So everything in this document, whenever you went over with your attorney, the stipulation, did you go over this with your attorney?
Yeah, I got that.
Okay. On the second page, there's a signature line. Is that your signature there?
Yes, sir.
Okay. Did anybody make you sign this?
No, sir.
Did anybody threaten you to sign this?
No, sir.
Anybody offer you cash money to sign this?
No.
Nobody gave you money to sign this, did they? Bribe you?
No, I wish I had some money, Judge Kim.
All right. I understand. Okay. So did you sign this voluntarily?
Yeah, I signed it like because I wanted to. Yes, sir.
Because you want to. Okay. Thank you. So I'm going to ask, is everything in this document, is it true or not true?
Yeah, the intentionally and knowing, yeah, stuff like that. Yes, sir.
Yeah, but everything in this, we're stipulating, so you can't go back and argue a single word out of here. You understand?
Yes, sir.
Okay, so is it true or not true?
True.
All right. Are you saying true because it is true and for no other reason?
Because it is true.
Thank you, sir. All right. So, Ms. Farmer, waive closing.
Yes, Your Honor.
Mr. Pearson, waive close.
Yes, Your Honor.
The court, having considered all the competent evidence from this hearing, will make a finding of delinquency. Specifically, the court will find the allegation in the petition in paragraph 1 was established by the evidence. The court will also make an affirmative finding that a deadly weapon was used. That will conclude adjudication for this matter. Now, the court will call cause number 323-114-528-20. This is styled in the matter of Joshua Ballard. The court, having previously adjudicated this child as delinquent, we are now convening for a disposition hearing. State waive open.
Yes, Your Honor.
Any exhibits from the state?
None, Your Honor. We do have witnesses we would like to call.
Okay, witnesses or allocution? Witnesses.
Witnesses.
Okay, all right, please call your first witness.
Thank you, Your Honor. The state calls Mr. Mike Jennings.
All right, Mr. Jennings, please raise your right hand and unmute yourself. Do you solemnly swear the testimony you're about to give at this cause currently at trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, thank you. You may lower your hand. Ms. Farmer, please proceed.
Thank you, Mr. Jennings. Could you please tell the court how you're presently employed?
I'm employed as a juvenile probation officer here in Tarrant County.
And are you the probation officer assigned to the respondent in this case, Joshua Ballard?
Yes, ma'am, I am.
And how long have you been his assigned probation officer?
Since approximately the middle of March of 2020.
Previously, the court took notice of a social history that was filed with the court this morning. Did you help prepare that document?
Yes, I did.
And what is your recommendation on this case?
Well, we're recommending to the court to consider placing Joshua Ballard at the Grayson County Residential Treatment Center facility.
Has Mr. Ballard previously been on probation?
He has been on probation.
And was he on probation when he committed this new offense that we're here for today?
Yes, ma'am.
Could you please tell the court what services were offered to Mr. Ballard?
Mr. Ballard has he's had community service and restitution. He's still active on. He's had the electronic monitor 4 times. 1 time was completed, 3 times was a failure. And he was involved with the functional family therapy program through Lena Pope. That ended up being a failure to comply because of this current charge and him being in the detention center.
Thank you. Do you think at this time it would be in the child's best interest to be placed outside his home?
I do, yes.
And do you think that reasonable efforts have been made to prevent or eliminate the need for the removal of the child from his home?
Yes, I do.
And do you think also that at this time the child in his home can't be provided the quality of care and the level of support that he would need to be successful on probation?
Yes, I am concerned about that at this time.
I'll pass the witness.
Mr. Pearson?
No questions, Your Honor.
All right, please call your next witness.
Thank you, Your Honor. The state calls Mr. Jason Jarman.
You solemnly swear the testimony you're about to give at this cause currently at trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You may lower your hand. Please, Ms. Farmer, please proceed.
Thank you, Your Honor. Mr. Jarman, can you please tell the court how you are employed?
A placement probation officer with Tarrant County Juvenile Services.
And were you assigned to the respondent in this case, Joshua Pollard?
Yes.
Could you please tell us what placement was found for him?
The placement that was found was Grayson County in Denison, Texas.
And what kind of services would that placement be able to offer, Mr. Pollard?
First, the services being offered, he would have a psychologist, a therapist, case manager. He will have the opportunity to attend school, to do credit recovery if needed. And also he'll have a psychiatrist available also.
And how soon would Mr. Ballard be able to go to this placement?
Grayson County actually has a bed available now, so we would say probably in a couple of weeks we could have him transported down there. He has to have a physical and on their actual physical form, so within a couple of weeks.
Thank you. I'll pass the witness.
No questions, I'm sorry, Your Honor, no questions.
Ms. Farmer, call your next witness.
State rest, Your Honor.
Mr. Pearson, any exhibits or witnesses?
No, Your Honor, we rest.
Ms. Farmer, any allocution on this matter?
No, Your Honor.
All right, the court, having reviewed the social history and considering all the competent evidence presented during this hearing, will make a finding that there is a need of rehabilitation. The protection of the child and the public requires disposition to be made. The court will honor the stipulated agreement and probate this child on this offense, and a condition of probation is for the child to successfully complete placement at Grayson County in Sherman, Texas. The court will also make a finding that the child's parent made a reasonable good faith effort to prevent the child from engaging in delinquent conduct, and that despite the parent's efforts, the child continued to engage in such conduct. The court will waive any requirement for community service that may be imposed on a parent under section 54.044 of the Texas Family Code. Ms. Farmer, there's nothing in the evidence to indicate there was restitution needed. Specifically, Mr. Ballard, the reason for this disposition is that, man, Joshua, you're asking me for a chance, aren't you?
Yes, sir.
I mean, you know you can go away for 40 on this one, right?
Yes, sir.
Like you're begging me for a chance, another chance on probation, right?
Yes, sir.
But I mean, you and I have met before, right? And you know, if you violate probation one time with even a more serious offense, what do I normally do?
TJJD?
Yeah, I just send you TJJD, right? But your attorney, I've known your attorney, we worked side by side before I became a judge, right? He's a good, honest man. He's a hardworking man. He's a good attorney. Convince the district attorney to give you one more chance, right?
Yes, sir.
But is that just him fighting for you, or are you fighting for you too?
Me fighting for me too.
All right, but you're fighting for you. That means when you're on probation, when you go to Grayson County, you got to do right over there, right?
Yes, sir.
And when you get out, you understand you got to be right. You got to do right for your mom. Like, no, you can't do this EM violations and sneaking out of the house and hanging around the wrong people and smoking weed. Like, you're telling me that you're going to stop all those shenanigans until your 17th birthday. Is that right?
Yes, sir.
But for real?
Yes, sir.
But the thing is, so you're going to be 15 years old. You understand you can't do what other 15-year-olds do, right?
Yes, sir.
You're giving that up right now.
Yes, sir.
And so you're going to live the boring life until you're 17. Is that what you're telling me?
Yes, sir.
So back here, you know, you're level 1-0 now, aren't you?
Yeah.
You've been level 1. So right now you're level 1 outstanding in our facility. So what's a DNA back there?
Do not associate.
Right. So when you go home to your mom after Grayson County and she tells you not to associate with those kids down the street, what do you got to do?
Don't associate with them.
Yeah, you got to be at a level 1-0 in your mom's house. You got that?
Yes, sir.
You stay at level 1-0 in your mom's house, you and I will never see each other again. But if you do your own thing, man, we're gonna have problems. Right?
Yes, sir.
Joshua, you know I like you, but you know, no matter how much I like you, you know, I will send you to TJJD, right?
Yes, sir.
Okay. That has nothing to do with me liking you. That has to do with you doing what you're supposed to do. Like I'm holding you to your word right now as a man. You're telling me that you want probation because you're going to do right. That's
Yes,
what
sir.
you're telling me?
Yes, sir.
Okay, I'm going to trust you. I'm going to trust your word as a man. All right, but that means on the back end, if you mess it up, I'm going to hold you to your word like a man.
Yes, sir.
Okay. All All right, finally, Mr. Ballard, I need to let you know this is an indeterminate sentence case because the DA waived the determinate sentence punishment. Your case cannot be transferred to the adult criminal courts for probation. I cannot commit you to the Texas Criminal Justice Department, right? Because I followed this agreement, you do not have a right to appeal. You have not been committed, so I do not think you have I think you do have a right to seal your records. That is something you need to talk to your attorney about, right? And there's nothing in the record to indicate that the victim or intended victim was under 17 years old. All right, is there anything that I missed, Ms. Farmer or Mr. Pearson?
No, Your Honor.
No, Your Honor.
Okay, well, thank you. That will be the order of the court. Joshua, don't burn me.
I got you,
Use your chance wisely, okay?
Yes, sir.
All right, thank you.
Thank you.
Thank you, Ms. Farmer.
Thank you.
Thank you, Mr. Pearson.
All right, so we're here for Rice.
Thank you, ma'am.
Mr. Gladstone's in.
Judge, I'll get Mr. Rice for you.
Okay.
Yes, I'm here.
Okay. Mom's here on Zoom. The sheriff just left to go bring Mr. Rice. Who's the prosecutor in yours? Mark, okay. Okay. Right, okay. All right. I'm gonna try and see what I can do here. Do we have any other attorneys waiting? All right. I'm gonna take care of some business with the attorney. And so what I want to do is I'm gonna create a little breakout room, Jalen, for you and your mom. Okay? I know you probably haven't been able to talk like anything like this in a while. So I'm just gonna create that. Tara, if you want to go ahead and add this, set the breakout room, and Jalen, you can too. All right, just I'll send a little reminder for you to come back to court whenever the attorney's not finished talking. This kid doesn't serve it, but it's the right thing to do. Yeah, it's like that first kid that served food busted, but
said it. I thought. Those two.
Attorneys. All right. So, Mr. Aniji, you were here
Judge.
for
Jamal Wright.
right. Okay. And that's with Mr. Reed. Is Mr. Reed here? Mr. Aniji, do you have an update on what we're doing right?
I don't think we're doing anything, Judge.
Yeah, that's exactly what judges love to hear. We're doing nothing.
No, we are not, we, not the judge.
Let's see.
Judge, the last time, which was at his detention hearing, I think about 2 months ago.
November 24th.
Sorry.
It was November 24th.
Yeah. I have not heard from the family. I have not heard from my clients. The last time they wanted to retain, they actually retained another attorney, but the attorney had conflict and they still wanted to retain another attorney. Since then, I've not heard. So I don't know whether they have gotten another attorney or.
Okay, so hold on. So I'm seeing Jalen, this is Jamal Wright, correct?
Yes, Judge.
He's not in detention. October 23rd, we reset it for 3 weeks for announcement.
That was before he was released.
Okay. So yeah, so he's not in custody. Are they here today?
No, it was set as a status update, so he wasn't scheduled to be there.
Okay. All right. Well, you know what? Let's just set this. Well, where's Mr. Reed?
He's in Reed.
Yeah, we don't have to.
It was in there earlier.
Why don't we just set this for trial for like end of the month and just be done with it?
Well, if they, well, I don't know who will inform them because.
I can. I'm going to go meet with them after this, as a matter of fact, today.
Yeah.
Okay.
Mr. I need you, if they hire any attorney, it's not your problem.
I really want them to, Judge, on this one. That's why I'm trying to encourage them.
I understand. Okay, so yeah, that's all I'm gonna do. We'll set it for trial by court by the end of the month. And then
Thank you. That will get them to action either way.
Right.
So it is the court ordering it set for trial.
Yes, we're going to set the trial by the end of the month, and I'm going to set it with an AJ. You care, Mr. Aniji?
Sorry?
You care if I set it with an AJ?
I don't have instructions, Judge. That's the problem.
There we go. So you can't object, or you're not going to object without his.
I can't.
All right, so
that's why I'm saying is the judge's order. So everybody needs to comply, period.
Okay. Yeah, so I'm going to set it by the end of the month, trial by one of the associate judges, just a TBC.
Yes.
Okay, and that way it'll just get done. It needs to.
That's correct, Judge.
All right.
We'll let them know at the meeting.
All right. Thank you, Ms. Bryant. Thank you, Mr. Aniji.
Thank you, Judge.
All right. Mr. Rice. So what we have here is your attorneys, they're going over some language. My understanding is you wish to waive certification, the certification hearing. And so the attorneys are working out some legal language on this one. And then hopefully we'll finish this one up today. All right. There's some stuff I'll have to go over with you. So what I'm gonna do is I'm gonna ask the sheriff to return you to your cell. And then I have another hearing starting up. And then my bailiff will call and have you pulled out if there is an agreement. Okay. Mr. Rice, do you have any questions for me? No? Okay. Was it good to talk to your mom for a little bit? Okay, good. All right, thank you. Hey, Sheriff, thank you very much for bringing this inmate. Sorry that we can get this done right now.
No problem, Judge. Just let us know.
All right, thank you. All right, so Mr. Shahan, Ms. Salinas, Mr. Jennings, we have detention hearings. That's in the other Zoom channel. So I'm about to end this one. All right?
Yes, sir.
All right, thank you, everyone.